Morning, everyone. I think we had a chance to touch base with everyone and get to know you a little bit. My name is Anthula Pomerning. This is Marcus Timian. We're with the law firm of MBHB. It's a nice, succinct way of saying McDonnell Boehnen Hulbert Berghoff. We are an IP boutique located at the corner of Wacker and Jackson, so right kitty corner from the Willis Tower. We focus on intellectual property, patents, and trademarks and copyrights, and trade secrets. All of our attorneys are engineers or scientists. So many of them have industry experience, and then they've gone on to go to law school. As far as our own practices, I'm a mechanical engineer. I was a patent examiner and then went on to law school. I initially started doing only prosecution, and then as I got more senior, I did more litigation. So now I manage some prosecution, I do litigation, I also do counseling work, and as well as counsel clients on trademarks. Marcus?
Yeah, Marcus Timian, and Anthula said we're an intellectual property boutique. Boutique makes it sound small. We're actually we have the largest collection of engineering patent attorneys, registered patent attorneys in the Chicago area now. We have 100 technical professionals, all with engineering or science degrees and either law degrees or passed the patent agent's exam. So we're actually quite large. I'm electrical engineering as my background, that's my degree, and I got that from University of Minnesota and went to law school there as well. So a lot of what I do is electronics, software, some mechanical. I don't do as much with trademarks like Anthula, but I bring trademark work in and she solves the problems.
It works.
Trying to think if there's anything else, but no, it's nice to be out here and talk to some people on the suburbs for a change.
Yeah, exactly. We're going to keep this totally informal. We picked some of the major topics to discuss, but honestly, we can cover whatever topic. If something's important to you, something's top of mind, something's causing you concern, we can obviously talk about that once we're done with these topics.
Yeah, that's what I'm actually looking more forward to that at the end. If there's people that have specific scenarios, you can change the names to protect
Yes.
those involved. But that's sort of more interesting, I think, for us. But
Right, so we will start with TC Heartland. I guess the backdrop, oh, there we go, okay. We have a very activist Supreme Court right now when it comes to patent cases. We're not quite sure why they've taken so much interest in our area of the law, but they have. And TC Heartland is the latest in the string of cases from the Supreme Court dealing with patent issues. So May 22nd, the Supreme Court issues a decision in TC Heartland that changes where a patent lawsuit may be filed. Before TC Heartland, people would engage in forum shopping. They would pick forums where it would be most advantageous for them to file a lawsuit in. Now, with this case, that's curbed that practice quite a bit. The statute, everything we do is statute-based. There's a statute that tells us where a patent infringement suit can be filed. It is 28 U.S. Code 1400B. And you can file a patent infringement suit where the defendant resides or where the defendant has committed acts of infringement and has a regular and established pace of business. So before TC Heartland, this statute had been interpreted quite broadly. It basically allowed you to bring a patent infringement suit wherever a corporation would be subject to personal jurisdiction. So in English speak, not patent speak, that means that wherever a company did business, that's where you could sue that company. So with this broad interpretation, a lot of people were going down to Texas. The Eastern District of Texas was known to be very friendly to patentees. And so a very large number of cases were being filed in that district. With this decision, the Supreme Court has interpreted what the word resides mean, and I know that seems it might seem a little silly that we would need a Supreme Court decision to interpret that word, But now, yes, we have a new interpretation. It relied on an old case from 1957, and the Supreme Court found that what the term reside means is that it's the state where a corporation is incorporated. So that is where now a corporation can be sued. That's what that means in that statute. Okay, so, oops, sorry, I'm having a little issue here. So with this decision, no longer is everybody rushing to the Eastern District of Texas to file their patent infringement suit. This is the data. So TC Heartland comes out in May. Before that, the Eastern District of Texas is shown in blue. So you can see that a lot of cases were being filed in that district. Once the decision hits, very few cases are being filed in that district, because now they need to be where a company is incorporated or where they have a regular place of business. So since TC Heartland, a lot of cases are being filed in the District of Delaware. I think they have, the statistics I just heard is 20% of all patent lawsuits are being filed in the District of Delaware, because the District of Delaware that's where a lot of companies are incorporated. They're Delaware corporations. So it makes, you're not going to get a venue challenge when you file in Delaware. The Northern District of California is also a popular district, because that's where a lot of tech companies are based and they're doing business. And then also our own district has gotten an uptick of cases because of this. Oops. Sorry, guys. Yeah.
When you mentioned that it's where a corporation is incorporated or resides.
Right. So incorporate or reside, that's what that means, right?
So if I open up an office in Texas and put 2 salespeople in it.
Okay, so we're going to get to that, actually. There was a recent decision that addresses that very issue. So the courts are not sure. Some courts are viewing this as it's not a change in the law. That case was around since 1957. It's just reaffirming old law. But there are other courts that are saying, hey, you know what, that's not how business was being done, and it's a complete shift in the venue landscape. So the courts are kind of grappling with what is this decision, how important is it? What we do know is there have been a lot of motions to transfer cases for lack of improper venue. You can see the statistics. I think they kind of speak for themselves. Before TC Heartland, there would be some challenges to whether a case was filed was proper or not. They would try to get it transferred in some cases, but clearly you can see I think we're at 400 motions to dismiss now since TC Heartland. Some of them are being granted, some of them are being denied, and some of them are not being addressed for various issues. Thank you. Okay, so back to your issue. So TC Heartland, after TC Heartland, we had one case in the Raytheon versus Cray. That case, Judge Gilstrap issued a decision, and he had a very broad test of how he found whether a company had a regular and established place of business. The parties didn't necessarily agree with how the judge address this issue, and so they asked the Federal Circuit, which is the Court of Appeals that focuses on patent cases, to address this and see, well, did they make the right decision? And the court said that the appellate court said the district court abused its discretion. It applied an improper standard and clarified it for us. So now, in order to find a regular and established place of business, you have to have 3 things. You have to have a place, and it must be a physical place, an office in a district. It has to be regular and established. It can't be something that you just pop into once every couple of months. It has to be some kind of regular activity. And it has to be the defendant's property. Office, it can't be, for example, the house of an employee that works remotely. That's not going to be enough. So this decision has provided a bit more clarity to figure out, what is a regular and established place of business. Thank you. So, after TC Heartland, oh yeah, go please.
Another,
Yep.
have they thought of looking at the length of time that residence, if you
Yes.
will, has been open and operating?
Yeah, so all of that, decisions in the law, you have to look at all the circumstances. So all of those facts will be taken into consideration to make that determination. Absolutely. It can't be something that, oh yeah, now we have an office, so now we can sue here. Yeah. That's a little transparent. And so what some courts are doing is allowing discovery. When this dispute comes up, they'll allow a limited amount of discovery on this issue to make sure you find out how long has that office been in place. How often is someone in this office? Is it once a year? So the courts are allowing limited discovery on this issue to make sure that they're making the right decision. After TC Heartland, there were a lot of critics. Oh my God, this is going to be the end of the world kind of thing. Some people thought that this would lead to more lawsuits being filed in different districts. We haven't seen that yet. Some people were concerned that people would have to file in districts where judges aren't as patent savvy. We haven't seen that transpire yet. A lot of the cases are being filed in the District of Delaware. They are probably the most experienced patent court. They are currently missing 2 judges. They have a judge on senior status, but what they're doing to deal with all of the new cases is they're bringing in judges from other districts. So that district is doing a great job dealing with the influx of additional cases. We'll have to see once these cases actually proceed to discovery and go further down on the schedule, how they will manage it. But maybe by then they'll get their 2 missing judges, and they're asking for a 5th judge, so hopefully they'll get that to deal with all of the additional cases. So how do what should you be concerned about? Obviously, if you're thinking of initiating patent litigation, you definitely want to think about this question and what is proper venue. So definitely talk to your counsel about thoughts on, okay, where should we be suing? Had you thought about suing in the Eastern District of Texas, that's probably not the place for you. So that's definitely something you need to think about. And then if you are a defendant in a patent infringement lawsuit, this is your opportunity to challenge the court that you're in if you haven't done so already. You wanna? Okay, so that's it on TC Heartland. Marcus,
yeah, just a couple points about TC Heartland that I have. I'm currently in a situation where we filed a lawsuit in the Western District of Texas, which doesn't have the reputation of the Eastern District for being patent friendly, but it's where the inventors were located and everything else. But we filed it before this TC Heartland case came out, and the defendants are actually based in Northern California. Northern District of California is a much more defendant favorable district. It's a longer time frame. The juries that you get there are typically more educated on technical issues, so they'll understand differences between sort of what might seem like tiny technical features that someone who isn't skilled in technology might not understand, and they'll just look more at the overall outcome. So we're dealing with one of those discovery motions right now to try to conduct additional discovery, and we might end up having to move the case to Northern District of California. But one other thing that might happen is companies like Apple, when they're deciding whether to open these Apple stores in every single big city, they might take this case into consideration, just because if they can be hailed into court in Beaumont, Texas, or someplace like that, just by having an Apple store in Houston, maybe it's not worth it to open an Apple store in Houston anymore, and they might just keep it to a few bigger cities that make sense for them market-wise, but also that aren't going to have the potential downside. Apple gets sued all the time for its consumer products. So Oil States Energy Services, this is another Supreme Court case. It hasn't been decided yet. The court has granted cert on the petition that Oil States filed, and So it's just in the petition stage, and now a lot of different parties called amicus curiae are filing their briefs in support of one party or the other, and this will be heard in November. Yeah. I guess I could still use a laser pointer.
Yeah.
So this case is about a new procedure, relatively new procedure. It's been around since around 2012, 2013. Prior to the American Invents Act, which was the 2012 act, the way you challenged patents, if you were a defendant in a lawsuit or someone else, was through litigation. And there were some other ways to challenge, but this AIA created a new process called PTAB trials. It's Patent Trial and Appeal Board. So it's all at the patent office. There's patent judges, and it's only about invalidity of patents. It's not about infringement or anything. So it's about invalidity based on prior art, and for some of these based on other issues, like whether it's ineligible subject matter or if there was inequitable conduct. But the biggest of these is inter partes review, and that's where there's two parties, the patent owner and the petitioner that filed a petition about the patent being invalid, and they basically conduct a mini court proceeding with discovery, including depositions, written discovery, interrogatory type discovery, and there's briefs, and then there's a hearing before a judge. There's no jury involved. And this case is, well, these PTAB trials are intended to be less expensive than litigation, and they take a lot less time. It's typically less than a year or so to get it resolved from start to finish. Since 2012, the PTAB, which is the Patent Trial and Appeal Board, has received around 7,000 of these petitions, and they've issued 1,500 or over 1,500 final decisions. Many of these petitions are on the same patents, so you can have multiple parties attacking a single patent. And most of the patents being attacked are also parts of parallel litigations. So it's sort of a shortcut way to address some issues that are going to be resolved in a court otherwise. This it's kind of a hard to read slide here, but what I want to point out is of those 1,500 petitions that have been granted, so you have to have the PTAB consider your petition to invalidate a patent, you need to have your petition granted, and so it has to meet certain form requirements, but it also has to satisfy the PTAB that there's a reasonable likelihood that you're going to be successful in invalidating the patent. So of the 1,500 that have been petitions instituted, almost 70% found all the claims of the patents unpatentable. They're a very small percent, 0.4% allowed some of the claims to be amended. 14% found some of the claims unpatentable, some patentable, and then all claims surviving unscathed is only 16%. So most of the patents that go through this IPR proceedings, or the PTAB proceedings, which could include some of the others like the covered business method and post-grant review, which are a lot smaller numbers. Most of them are being invalidated, at least in to some extent. So it's a big issue. And it's resulted in the PTAB being called a patent death squad. So a lot of people say the PTAB is predisposed against patents, and that they're a threat to patent rights. A lot of people have said that since patents are being invalidated, people's property is being, the value of people's property and companies' property is being diminished, and it's also devaluing the companies themselves. So a former judge for the Patent Appeals Court, Judge Rader, said, yeah, you have 7,000 people giving birth to intellectual property rights, and he's referring to patent examiners there, which are sort of promoting the patent process. And then while on the PTAB, there will soon be as many as 300 administrative patent judges acting as death squads, killing patent rights, property rights. So this is a judge that is very familiar with patent law, and he's making comments like this. So in this case that Oil States was the patent holder, and they went through an inter partes review that Greens Energy was filed the petition for, and so the issue is stated right here. Is the IPR proceeding, and then it would carry on to other PTAB proceedings, does it violate the Constitution, which guarantees the right to a trial by jury? And that's through Article 3 of the Constitution. So it's basically a constitutional law case about whether the executive branch of the government can take away your property rights. And typically that's handled by a judge that's an Article 3 judge, not an executive branch of the government like the U.S. Patent and Trademark Office. And so a couple items that the court needs to consider are, is this right of a grant of a patent, is it a public right that the government can grant and control through the federal statute, or is it more like an individual private property right, like your house or the land that your house is on, and there's no clear case law on it. It's a decision that patent attorneys and companies that have a lot of patent portfolios are really looking hard at. There's a lot of briefs being filed in support of one side or the other. So we'll just have to see how the court comes down on it. Depending on how the court decides, it's going to be a pretty big decision for either patent holders or for companies that get sued all the time. If IPRs are considered to be unconstitutional, it's going to remove a cost-effective and quick way to get rid of patents that might not be valid or that are hindering innovation in the industry and moving along the industry. But on the other side, if you are a patent holder and you have a legitimate innovation and invention, you probably want your property rights to be decided by a judge and jury, not a panel of judges that can just take away your rights. And there's different legal standards too, which is another big issue.
You mentioned property rights. Does eminent domain have any impact on this?
You know?
No, I do not believe
Yeah.
that's the case.
Yeah.
I don't think there's a connection.
Yeah, I'm not aware of it, but.
Yeah.
Are there, for the 1,500 or so that were challenging, the validity, are there any patterns to the types of entities that are doing this?
There's patterns to the types of patents.
Yeah.
So there's
Okay.
a theory that the reason why so many were initially filed and so many of the ones that were instituted, they found the claims to be invalid, is because they were the patents that maybe should not have issued. So that is the theory. That's actually a very popular theory, that's why the rates were so high initially. And then as time goes on, it's normalizing. I would think that it's the same type of patents like business method patents.
Yeah, there's a lot of the software patents, but there are also another class of patents that are being widely asserted in litigation. So there are sort of pooling of companies, they're pooling resources to attack, what might otherwise be strong patents with, from many different sides using lots of different prior art. And there's even some companies, Unified Patents I think is one, that their business now is just attacking patents using these IPR processes. Right. And yeah, they're not quite trolls. They're a little bit different than trolls. They're sort of like reverse trolls. Yeah.
Memberships. You can. They go to companies and ask for a membership, and you join, and then you can.
Get sued. They will help go after the companies, the patents that are the problems. Yeah. And it's not clear what would happen if the court decides that IPRs are unconstitutional. It's not clear what's going to happen to the patents that have already been invalidated. It's kind of a sticky legal issue. It'll be fun to see what the court says. Oral argument is November 27th, and we can expect a decision a few months after that. But it's one of the hottest areas right now, and there's a lot of articles being written on it. There's a lot of quote lobbying being done in the form of PR efforts that the industry's reading. Maybe the courts are reading. Who knows? But any questions about this case, it's a case in process, and it's one of those stay tuned.
No, and on this issue, it's definitely, like Marcus said, it's definitely a hot topic. There is a lot of people are losing sleep over this issue because a lot of companies have utilized the IPRs as a means to attack what they perceive as an invalid patent, or as a defense. If they get sued in a patent infringement case, guess what? They're going to file an IPR if they can. So this is definitely a hot topic. A lot of people are worried about it, and we'll see. With our activist Supreme Court, it'll be interesting to see what the court decides to do. Okay, so now we're leaving the court, and we're going to, this is very practical information for those of you that have trademark registrations. How many of you, I know you have a registered trademark. Anyone else have experience with the trademark process? So you're aware, you file for a trademark, the trademark attorney reviews it. If there's no conflicting marks, he or she will issue a registration. The office doesn't want to just keep on issuing registrations and keep them on the principal register if you're not using them. So they require you every so often to file affidavits saying, yes, I'm using the mark, and here's an example of how I'm using it, and here's your fee. It used to be it used to be a lot easier to file these declarations of use. The office wasn't as strict, but now it's getting stricter. Oops. And no, you're good. You can go ahead, switch. Okay, and the reason why they did a pilot program, and 51% of the 500 registrations selected for their program, the trademark owners failed to supply the additional proof of use for the goods that they had claimed. And so the office is like, well, we're going to get more strict about this because we want to promote the integrity of the principal register. So between the 5th and 6th years from the time that a trademark registration is registered, you have to file a declaration of use. And that is basically a statement. It can be filed by the attorney of record if they have knowledge of it. A lot of times what I do is I send it to my clients because they have knowledge, they have firsthand knowledge, and so they can electronically sign it, and then I file it for them. But basically saying, yes, trademark office, I'm using the registration, I'm using it for the goods that I said or the services that I said I was going to use them for, and I've used it for the time period that in question.
You have to provide any evidence?
You have to provide, that's on the next slide. So in addition to this statement, this declaration, you also have to provide an example. It could be a photograph of the mark on the product. It could be a label. It could be, depending on what it is that it could be a picture of a website, as long as it's some kind of evidence that shows that the mark is being used in commerce, and the fee. If you don't file this, then the registration's canceled, because the way the office thinks of it is, well, if you're not using it, then you don't need a registration, and we're going to free that off of the principal register. In the past, if you listed a number of items in your description of goods and services, you only needed to really give one specimen. And the next slide shows an example. This is actually one of our clients who's a manufacturer, and they're located in Crystal Lake. And their registration lists storage boxes, tool boxes, strong boxes, drawer storage units, shelving units, and transfer tanks in Class 12. And in the past, you would only have to submit evidence of use of the mark for just one of the goods, so it could have been storage boxes. Now, you'll have to, the office may actually push back and say, okay, I want to see evidence that you're using it on everything. And the proof may be, more declarations, more examples of the use, more affidavits. They actually may issue an office action, pushing back on that, and pushing back on your filing and saying, okay, I need more evidence that you're using it. So for you, what's best practices? If your registrations come up and you need to file Section 8 and 15 between the 5th year and the 6th year, you need to make sure that you really are using the mark for all of the goods and services. And so at the time, when you're putting together the one specimen to file, put together specimens on everything, and then have that ready should the trademark attorney come back and say, we need additional evidence. And that is it on that topic. Any questions on that? No? All right, trade secrets.
All right, so let's go back here. So you can protect innovations using patents if it meets certain criteria. Another way to protect innovations and other confidential information that has value is through trade secrets. And so the Defend Trade Secret Act, prior to this act, each state had its own state law relating to how to protect trade secrets and what a trade secret was and how you had to go about showing that trade secret misappropriation and theft and there was some uniformity. There's a Uniform Trade Secrets Act, but different states adopted it in different forms. And as the next slide will show, there's a couple states that didn't even adopt it at all. So go back one. So the Defend Trade Secrets Act was passed in just last year, and so it's been around for just a little bit over a year. It created a private federal civil cause of action for trade secret misappropriation. So private meaning any citizen could bring it, any company. Federal, it's across the US, not just in any state. Cause of action for trade secret misappropriation. It allows ex parte seizure, so one party can petition the court to allow sheriffs, federal law enforcement agents to go into the trade secret misappropriators and take like a computer or whatever is the cause of the trade secret theft. And it also includes whistleblower protections. So if you are, let's say you're in the insurance industry and you're aware of fraud going on in your company, this protects you from giving it to law enforcement agents and giving trade secrets to law enforcement agents, and you wouldn't be able to be liable. Let's go to the next one. For criminal or for this trade secret theft. So I guess the starting point here is what a trade secret is. It's a lot of different types and forms. It's patents only cover inventions basically, but trade secrets are financial, business, scientific, technical. It can be sales information, customer lists. It can be physical, electronic, graphical. A lot of other different techniques. So basically anything that gets its value from being secret and not out there in the public where you control access to it is subject to trade secret protection. And as I mentioned, in the past it was under state law. Massachusetts and New York were two of the jurisdictions that did not adopt the Uniform Trade Secrets Act, which was the predecessor, and that's partly because they have large biotech presence in Massachusetts, and they wanted to make it harder to show theft of trade secrets for some reason. And there's a lot of steps that are involved in the Massachusetts and New York laws. And the other way to do it was not a private civil action, not a private federal action. It was through the economic espionage, and where you had to go through a U.S. attorney to actually raid the company and make sure that there was indeed trade secret theft in some form or another. So now that there is a federal cause of action in the form of the DTSA, you have a uniform body of federal trade secret law that the courts will continue to develop and companies can rely on to know whether it's worth filing a suit or whether they're in the right or the wrong. You've got uniform court procedures, the Federal Rule of Civil Procedures, gives you nationwide subpoena power. Prior to that, if you were under a state law trade secret action, you had to, you're kind of limited in the depositions or discovery you could seek, depending on which states you were trying to seek discovery from. Now there's nationwide subpoena power. You can get a subpoena from another federal court, another federal district court, wherever the witness is located. And that, along with that, is the expedited and simplified access to evidence in other states. That's again the subpoena power through the federal district courts. There's, discovery has been going on in the federal court system in somewhat organized manner. And then the ex parte seizures process that I mentioned, and that's what we're going to talk about next. after this slide. During the past year, so it is possible to bring both the state law claims and the federal law claims together. So in Illinois here, you could bring a DTSA action under the federal law and also bring your state law Illinois Trade Secrets Acts together through supplemental jurisdiction, it's called. And you can also bring other non-trade secret acts or actions into the federal decision as well, like breach of contract, unfair competition, and others. So for ex parte seizures, there are other ways for courts to go after and stop trade secret misappropriation. So this is not a favored way of doing it, but the court can issue an order that provides for federal law enforcement officers to seize property necessary to prevent the propagation or dissemination of the trade secret. So the person complaining of trade secret theft needs to petition and show that it's clear that the alleged misappropriator would disobey a temporary restraining order or preliminary injunction, or would destroy, move, or hide the trade secrets. And typically, courts are going to find that a temporary restraining order is going to be enough, and violating that's going to put them under severe penalties that in most cases would not require this ex parte seizure procedure.
What's the big difference between, when would you do a TRO versus preliminary injunction?
Preliminary injunction or ex parte seizure?
Sorry, seizure.
Yeah. Well, TRO's temporary restraining order is a lot easier to get done. It's you just need to show a likelihood of success, and then the court issues an order that you're not allowed to, or that you have to maintain everything in its current form, perhaps, and just can't destroy anything. And
it's kind of easier to expedite.
It's easier to expedite. There is a chance that things will get destroyed, and then if you hire a forensics firm with for discovery to prove that it was done.
The fear for this, the ex parte seizure, of an employee, and this person has trade secrets on his laptop, and he's on the next flight to somewhere very far away in the morning. That's the situation that that is meant to address, I think.
Yeah.
Immediate, yeah.
For an ex parte seizure order, but you don't have to give notice to them. They'll just have a federal law enforcement officer show up on their step, and they can have local law enforcement with them, and they'll take whatever the judge says in the order. So there's been a few decisions on this, and some have gone almost all have gone the temporary restraining order route instead. There's been some that have denied the seizure order application. And it's all just based on the judge deciding that it's really not necessary to go the route where a federal law enforcement officer just shows up at your house and just takes stuff from you. It's more based on the TRO being a reasonable alternative. Yeah, the one case where there was the ex parte seizure, there was a good showing that there was a real likelihood this person was going to be destroying the trade secrets. Whistleblower protections. This, as I mentioned, it insulates individuals from this trade secret misappropriation liability under state or federal law if the whistleblower is trying to prevent or report violation of a law, either state or federal. And so far there's only one case so far relating to disability insurance claims, and I think the next slide I have some facts on it. I don't, but if you go back to the one, this Unum Group versus Loftus. The Loftus was an officer at this Unum Group insurance company, and they were under investigation for some sort of claims scam that was going on, and Loftus, he was interviewed, and a couple days later he took a couple boxes home and his laptop, and so the insurance company, Unum Group, filed a Defend Trade Secrets Act complaint against him for trade secret theft, saying he stole the boxes and the computer. He gave the computer back, but he relied on this whistleblower protection to say that he should be immune from the lawsuit. This court actually didn't exactly do what I think the Congress intended with the DTSA. The immunity means that you really just can't be sued for or liable for trade secret theft or misappropriation. What this court did is treated it as an affirmative defense instead of an immunity, saying that we'll consider it, but you haven't made a good enough showing yet, so we're going to have to go through the litigation. And so it's going to, Mr. Loftus is going to have to spend money defending against this lawsuit, for trade secret theft now that he might not have otherwise had to happen. So that's sort of been the criticism with this case, but it is the only one where there's been at least some success he gave the information to his attorneys and has been sort of protected somewhat. It's only been a year, so it's really too early to tell the impact on it. There's been one case where the jury, they actually came up with a $2.5 million verdict. $500,000 of it was for this liability under the Defend Trade Secrets Act. A fig jam company, Dalmatia, was using Food Match as their distributor, and after 10 years they decided they didn't want to use Food Match as a distributor anymore. Food Match went to the manufacturer that Dalmatia was using and decided to start coming out with their own fig jam, and the recipe for the fig jam was a trade secret, and the jury was convinced, and so they gave a $500,000 reward, and that's sort of that's the first Defend Trade Secret Act judgment. There's a lot of other interesting cases in progress. Probably one of them that's getting the most press is Waymo versus Uber. This is the Google self-driving cars, and company that's predecessor to Uber that Uber acquired. They hired on one of the main engineers from Waymo, which is the Google entity, and so there's a big controversy there. And Uber came out right away with self-driving trucks within 6 months, and Waymo claims they were using their technology, their trade secret technology. But for now, there's a few things that are kind of practice tips. One is this whistleblower immunity that I talked about. In your employment agreements and policies, any of them that are arising after the passage of the DTSA in 2016, if you include a notice of these whistleblower protections, then it can allow you, as the company, to recoup your attorney's fees if the whistleblower provision is unsuccessfully invoked, if there wasn't really a good reason for invoking the whistleblower provision by the employee. If you have notice of the policy, then you're able to get attorney's fees back if you can make a showing that the employee wasn't entitled to the whistleblower provisions. And second, you want to, like always for trade secrets, you want to make sure that you're following good guidelines for trade secret protection. Keep them secret. You want to keep access to the trade secrets limited to those who need to know and not others. Use non-disclosure agreements, and just always take care to avoid disclosing them. That's how you keep trade secrets as trade secrets. And that's all for the DTSA. Are there any questions about DTSA? It's still early. We don't have a whole lot of guidance yet from courts or anything, but and if there aren't, then I guess we're onto the part where it's sort of free form. If you have specific IP questions or anything else that came up regarding these topics here, feel free to ask them now. Or you can feel free to email specific questions or ask us afterwards individually too. Yep.
There's one instance, one issue that's been coming up in our industry, which is what's determined as gray market product. And what it is product that might have been destined for Latin America that is bought in Latin America and then shipped into the U.S. under the same brand name. What the argument appears to be is, this is HP/Cannon's argument, is that the product is destined for the Latin American market. It's meant to be sold in that market, not in the US market. And because of regionality, they have the right to sell it there and not have it sold in the US. There's also about a 20% cost difference between buying it in Latin America versus the US. So the product is brought in and then sold at a discount. Is there any
Yeah.
basis for this? Is there legal issues involved with transshipping goods from a foreign country into the US, even though the patent and the trade and even the brand name and the part numbers are identical?
Well, it's a lot bigger issue in the pharmaceuticals industry, and there you're seeing, you know, pennies on the dollar for drugs in some countries, and for the exact same drugs. But yeah, it's definitely a big legal issue, and you know, we represent a printer manufacturer, so they're probably on the other side, but you know, not one of those who used to. Yeah, right. Yeah. So, but there are.
companies too.
I mean, one way that the companies typically try to handle it is through contract law. Is you know, when they sell it to these distributors or customers in other countries, they try to make contracts in place that, you know, by selling it somewhere else, they would be violating the contract. And, you know, as you mentioned before the talk here, there was a recent case, the Lexmark case, involving trying to contract away, you know, your right to sell it later on through the patent law statute. That's not allowed anymore, but it's still allowable to do licenses or contracts with who you're selling the companies to. If you're selling directly in a foreign country, you know, you can still have the contracts to customers, but it's really not usually a good idea or viable to sue every customer that could potentially ship it over. And I don't know, are you familiar with the Kurtzing case, the facts? Okay. Yeah, that was one having books that were sold somewhere else and imported in, and yeah, I'm not quite as familiar on that as I can. I know there's a case, hasn't come up for me enough to really get into it deeply, but you know, pharmaceutical industry is where it comes up mainly, and you know, I think the Lexmark case was probably a good first step for your industry, and it did get a little bit into sales abroad and bringing back in from the patent context, but not just when they're not covered by patents or anything. And another area where sometimes there are protections are in certifications, like Underwriters Laboratory and those others. In some countries, they might not require the strict certifications, or it might not be as in demand or necessary as in the US. And so the Customs and Border Patrol is sometimes involved as a way to prevent introduction into the United States of products that way. And I guess the FDA might be another way for pharmaceuticals. But if it's the same drug, you know, maybe they probably have to make a showing that it is indeed the same drug, which might be a difficult proof. You have anything else to add for this? It's a good question, but it's not, I think it's still a question that's a little bit up in the air.
Well, and that's just one aspect of it. I mean, you can look at things like clothing. You know, if you buy a Prada handbag in, I don't know.
Yeah, counterfeits. Well,
Counterfeits?
yeah, so
That's a different
Counterfeit is
issue,
different.
yeah.
That's
Yeah.
a whole different world, but I'm talking about a genuine item that is purchased at a store. Quick example, I can go to England, I can avoid taxes in England by paying and getting my VAT tax reimbursed to me, bringing it into the US and not having to pay tax on that product that I purchased. So there's a cost savings that's there. If I do it for myself, it's fine. If I bring in a container load, now all of a sudden it becomes an issue.
yeah, and I'm not a tax attorney, but I think a lot of states are starting to crack down on just what's the alternative to sales tax when you, like, if you buy something on newegg.com or something and they don't charge sales tax because you're in a different state, you're supposed to.
You're supposed to report that.
Yeah, and so I wonder.
As a personal.
So I wonder if there's a violation of state tax by doing that they're just not getting caught, and maybe they'll catch up to them eventually.
Cigarettes again, right?
Huh? Yeah. Right. Yeah.
Cook County tax and
Yep,
cases.
yeah.
Or pop.
Or
Yeah.
pop
Or
now,
pop.
exactly.
Or, well, that was been repealed, though.
Well, but still, yeah.
Gray market code.
Do you have anything to add from your perspective as, do you do computer forensics, or your company does,
no, we
right?
do.
I mean, trade secrets is obviously a big
Those employees
area.
you were talking about who are getting on the plane are as prevalent, I think, as that they've ever
Yeah,
been.
people trying to wipe hard drives to cover up their tracks, and you know, as law firms, our ability to detect that is a lot greater now than it was, you know, 20 years ago, 15, 20 years ago, just because there are companies that they have specialists that do that. So we have a lot of tools to kind of help with trade secret misappropriation. And we even had one of our litigations that we had involving electronic trading company. The other side was caught with their expert changing source code, and we were able to identify that, and the judge awarded $1 million in sanctions and some other penalties and default judgment. So it was a huge victory from just looking at using forensics to identify changes in source code. But the same sort of forensics can be used for trade secrets and also identifying infringement too.
Yeah.
So we've made use of improvements in technology in the past too.
And I gotta say, like, a lot of that is starting to happen on this now.
Yeah, right.
You know.
Yeah, we have people that don't really even use their computers at all. They use only, you know, Surface Pros or iPads and
Yeah.
you know, phones. So
They're still around, but
Any other comments, questions?
you know, in the manufacturing industry, I don't know if your companies are adverse to or involved with 3D printing at all, but that's going to be another big area where just the transfer of files across the country to allow for easy manufacture, you know, perhaps not as good or the same materials as you could using conventional manufacturing techniques, but it's an area that maybe the law hasn't caught up with, so there's a lot of questions about how to address infringement in a way that makes sense monetarily. You know, you can identify infringement maybe with one or two people, but it doesn't really make sense to sue those individuals that are printing possibly. So we're gonna have to see if the framework that was used for music by iTunes and others, if that's gonna work somehow for distributing the files that allow for 3D printing remotely, if that's gonna make sense in the same way that it did for music or not.
I think Disney's already done some things with that.
Yeah, Disney and Hasbro, there's some toy companies that have. They're trying to, I think they're more just doing test markets. There's also, some of these companies are getting patent applications filed and getting patents issued on 3D printing and scanning technologies. Hasbro made their own little 3D scanner that was for kids. It was a little dinosaur that had a camera in it, and you put on the platform whatever you wanted to 3D scan, and you know, it could be a little Lego creature you built or something, and it would scan it, and you could put that file in your computer and, you know, either use your own 3D printer or take it to the library or send it to a 3D printing service, and then print up what your Hasbro 3D, it's either Hasbro or Mattel, what your scanner scanned for you. So that's sort of some of these companies that are really pretty traditional are testing the waters with 3D printing and scanning. Anything else?
Thank you.
thank you.
Yeah.
Letting us chat with you this